you very much. You know, Ross Perot had a running mate, and he said during his speech, he said, "Who am I and what am I doing here?" Well, my name is Kent DeJean, and I am the DeJean in LeSavio and DeJean. I've been practicing law now for 25 years. Just to kind of give you a story about the importance of marriage in society, my name is DeJean, but actually I'm a sixth generation native of the state of Louisiana. Our family was actually started by Bartholomew DeJean, who came from Toulouse, France. And he migrated here, and he left a very prominent home there and family. He comes to Louisiana as a commandant in the French army. He was Bartholomew DeJean du Bousquet du Lenac. We chopped it off, otherwise we have names all over the place. Okay? Of John. He comes to Louisiana. He is stationed in Opelousas. And what he does is he is protecting the settlers out there in the 17th century. A young lady from New Orleans brings her sister from New Orleans, and he falls in love with that woman. Felicite. He falls in love with her and he never goes home. But for the love of a woman and marriage, I would be in Toulouse, France today sipping champagne. It goes to show you the importance of relationships. We think of ourselves, but we don't think of the effects, generation-wise, of these relationships. I'm with LeSavio and DeJean. Our law firm does a number of different things. You're going to get a lot of different pamphlets here. We do a lot of different things. My law partner does Medicaid planning to help people qualify for nursing homes who are losing money there. He also helps qualify them for government benefits for veterans benefits. I do a lot of different things. I do bankruptcy. I do divorce. And I also do successions. And I do Social Security for people with mental and physical disabilities. So I do a lot of different things. Kind of a boutique, we kind of do a specialized thing. Take a look at your stuff. There's a very good DVD in there, especially people taking care of older parents that are concerned about Medicaid planning. You find it very interesting.
Actually, the DVD is not included in the packets, but I have enough for everybody. Whoever's interested in one, just come stop by over here later and you can have one.
So anyway, what I'm going to talk about today is divorce. This is the fun gossipy part of it, okay? And what I tell people is when I get started, I'm going to give you a bunch of disclaimers, okay, about this area. Number one, don't listen to what you hear about on TV, okay? Because people listen to it all the time and they think that's what Louisiana law is. If it is law, it's probably California law. So disregard that and erase all of what you've heard on TV from your memory banks. You're going to find Louisiana law is probably a lot simpler than you think. Number two, don't listen to your cousin. Oh yeah, how about those cousins? I had that bad experience with that horrible judge that was so corrupt, right? Don't listen to them. You know why? Because they're leaving out critical facts. Every case is different. As paralegals, you know that. Every case is different. So to say, my case applies to you is not necessarily correct. So disregard what other people have told. Also, what I want you to know is that I am painting with very broad strokes today. I am giving you, the shortened version of things. My law professors watching this are going to have an absolute stroke, okay, of what I'm telling you today. But I'm giving you the shortened, abbreviated version, okay? If you want the details, I've given you materials, okay? And so that you can use as your chance to delve in with more particularity as to what's going on in these statutes. Lastly, we're going to have a sense of humor, okay? Now don't get me wrong, divorce is a serious thing. I know for a fact it's serious. But you're going to be here for a long period of time. And if all I do is get up here and start writing off statutes and we don't have fun with this, guess what? The day's going to be a lot longer than it should be. Okay? Lastly, what I want to tell people is make sure you ask your questions at the end because we're going through a lot of stuff here, and if we get interrupted, I may not be able to get to everything. Okay? Very important. Divorce. Whether we like it or not, it is a reality that each and every one of us face today. When you look in that engagement section in the newspaper, half of those people will be divorced if they're the first time. That is a reality. It's anywhere from 41 to 50%. If we look at it a little bit closer, and now everybody's eyes are going to start really getting big, I can tell who's married, who got married when, because the peak of the divorce is from 20 to 25. That's where most first time. When you get married at that point, that's the people that get the highest. That's the highest level percentage. That's where the bulk are. We get a double whammy because most people, that's when they get married, 20 to 25. We have some other little bumps. Second and third time marriage. If you're married a second time, you will have a 60 to 67% chance of getting divorced. If you're a third time marriage, it will be 73 to 74%. I really see people's eyes. I can tell who's been married to someone who's been married a third time, because that's very sobering. These are very sobering statistics. Okay? And the reality and what has happened, and a major part of what's happened, is we have now reached a milestone in this country. The milestone is that there are now more single people in this country than married people. First time in the history of the United States, 48%. In Louisiana, we've had a lot more single people. We actually have 42% married people in this state. Divorce is a significant factor. Talk about the good old days. In 1950, it wasn't 48%, it was 78% of people were married. And that was only 60-something years ago. The vast bulk of people were married. And the divorce rate in Louisiana in the 19th century was not 50%, it was less than 1%. And it was mostly rich people. There weren't a lot of them. And they usually only got divorced because of adultery. That was it. What happened? What happened to us? What happened was the roles of women and the roles of men changed. People, these archaic ideas about women being barefoot and pregnant, okay? You heard about that. It's archaic to us today. But you have to understand, in the 18th century, we were in a totally different world. We weren't in a world where people had a lot of money. They were poor. We were in a world that did not have Walmart, that did not have electricity, that did not have water, running water, indoor plumbing. We did not have any microwave ovens to cook our meals in 30 seconds. What did we have? We had partnerships of people. Oh, they said a woman's place was in the home. It was very important. That sounds archaic today. They had to be in the home. They had to be in the home because we would starve to death if they weren't. Why? To cook a meal in the 1800s, average meal, you couldn't go to McDonald's to go get a chicken burger. No. It took you 2 to 3 hours to cook a meal. One meal. So that meant you were working 6 to 9 hours just cooking meals. Now, today we have 1.5 children. Back then, you know how many children there were? Average number in the 1800s is 8 children. There's a reason for that. Number one, your life expectancy is 35. Today it's 70, in the 70s. That's why you have to get married early. When you're 18 today, 24. You gotta get married early. Why? Because if you don't get married when you're 17 or 18 years old, you can't wait till you're 30. You're probably gonna be dead. Your children will be orphans. So you better get busy and you better have a lot of them. And here's a real big news flash for you. In the 1800s, believe it or not, children were financial assets. They were important. You had to have a lot of them. You know why? Because they were free labor. Okay? They were your social security. You didn't have social security. They took care of you. They were your disability policy. When you got old and decrepit, they took care of you. You need a bunch of them. And here's the most sobering fact of all. What happened in the 1800s was 20% of your children did not make it to adulthood. So if you had those 8 children, 2 were going to probably be dead by the time you reached adulthood. That means you're going to be left with 6. All of these factors are important. Just having a bath. You had to go out. If you wanted a hot bath, that was a real luxury. You had to go out and get the firewood. The woman had to get the firewood, light the fire, boil the water. That took 45 minutes. Washing clothes took 2 days. That batch of clothes is 45 minutes. Takes 3 hours for a woman to do in making. So a woman's role is very important. She is a partner. Today we've changed. We got all these inventions. We no longer have a poor society. We have a middle class society. Individuals are now independent of one another. There's still love, but we've lost that partnership component. Okay? So a lot of times when politicians try to tell you, well, there was so much more moral in those days. That's true, but it was a different world back then. Today, we need each other from an emotional standpoint, but we need each other less for a partnership standpoint. And that's what's happened in our society. Women today don't need a man to be working 14 hours a day, because you can take care of yourself. And a man, if he wants to be single, can be single. That's the issue, and that's what's happened. The reason I bring this up is because you're going to see broad swings in the law that's going to go from our legislature, for better or for worse. What happens is they tell us at times, we're going to change the law and make it the old-fashioned way. We're going back to the good old days. And then all of a sudden they realize, oh wait, we got to go back to the modern days. We got to recognize there's a modern component. And so you see this constant swing in the law. And I'll point it out to you as we go. Let's talk about divorce. And this is the first thing I tell my client. And when I use the word divorce, I am talking about a different concept than people talk about on TV. On TV, when people talk about divorce, they're talking about everything. Child custody, child support. And they think, I'm going to hold up the whole divorce. When I talk about divorce, I'm not talking about the incidental issues. Child support, child custody. I am talking about ending the marriage. That's it. One thing. That is divorce in a legal concept. We're going to talk about other issues, which we call ancillary or incidental issues. These issues include partitioning community property. That means dividing up what you got. That's another issue. It stands on its own. It has its own laws. Okay? Each area has its own laws, and they stand independent of one another. Child custody, child support, alimony, exclusive use of the home, harassment, disposal of property. All of these issues are separate issues, and they have their own rules. They are incidental in the effect that they don't ever have to be resolved. We can get a divorce and never settle our community. We can get a divorce and never settle child support or child custody. In other states, you got to resolve all these issues to get it done. That's why you got in California, I'm going to hold up the divorce. No, you can't. If you meet the requirements for the divorce, we don't care if you didn't settle these other issues or litigate these other issues. And you can't hold it up. Now, let's talk about annulments. I'm going to talk very quickly about annulments. A lot of people come to me and they say, I want an annulment. That blankety blank, we've only been married for 33 days and I hate him already and it's over. Okay? I'm going to talk briefly about annulments because people bring this issue up. And a lot of times they bring it up because it's this Catholic influence. We talk about annulments in the Catholic Church. I'm Catholic, I know I can say these things. Okay? But basically, there's that element there. When it comes to annulments, and if you really want to be entertained one day, go into the annulment section. Okay, they don't happen very often, but this is like reality TV. But this is like really, really good stuff. These are marriages. An annulment, in order to have an annulment, there are two types of annulments. One is a relative and one is an absolute. An absolute is so bad that you never were married And there are two things. You don't even have to go to court to get it approved, to say you're enough. Okay? It's so bad what you did. Not only that, but you cannot confirm it. In other words, you can't rectify it by living together. Okay? There are another kind called relative annulments. Relative or less significant. You got to go to court to get them approved to say you never were married. And you can confirm it. Okay? You can confirm it. Now, absolute. These are the biggies. You didn't have a marriage ceremony. If you didn't have a marriage ceremony, you're not married. Same sex. Absolute. If you married another person of your same sex, you are not married and you don't have to go to court. Can't make it up. Third, already married. This happens more often than you may think. Here's why, because a lot of times people get this phone call with your wife saying, I filed the divorce and I promise I'm getting the judgment tomorrow, and they didn't get it. Okay, this happens a little bit more than you may think. My personal favorite, not present at the ceremony. Can't send a power of attorney. This happened quite often in the old days. Ladies, let me quote you this. Here's a news flash for you. If your husband or prospective husband does not show up at this ceremony, that's probably not the most ideal marriage. Okay, we're not starting on the wrong foot. And lastly, you cannot marry your ascendants or descendants. You can't marry your mom, your dad, your grandpa going up. You can't marry your children, grandchildren going down. You cannot marry your aunts. You cannot marry your first cousin. You can marry your second cousin, and your third cousin, and your fourth. But you can't marry anyone ascendant, descendant, or within a fourth degree cloud.
Second cousins can marry.
Second cousins can marry. Relative. Now this is the ones we always talk about, going to Vegas and getting drunk. Okay? If there's duress, violence, shotgun wedding, it's got to be at the time of the wedding. They can't just be threatening you before the wedding. It got to be during the ceremony. Okay? That is a relative no. Next thing is going to be influence of alcohol or drugs. I went to Vegas and she and I got wasted and we got married. But it's got to be incapable of discernment. Not just a little bit drunk, you got to be really drunk. Okay? Other thing is, and I don't like these words, but this is what the statute says, mentally retarded. If you're incapable of discernment because of mental retardation, or you're too young, cannot understand what you did, in those cases, you have a relative nullity. You got to go to court to get it approved. But here's the thing, if you and I go to Las Vegas and we get drunk, and all of a sudden I realize, well, she's pretty nice looking. Maybe we ought to try this marriage out. And I try it for a couple of weeks. Guess what? I'm now married. So you can confirm these relative things. But unlike the absolute, you can do these. That is nullity. Okay? So as you can see, it doesn't happen very often. When it does, it's very entertaining to look at. Now, why do I need a divorce? Because here's the thing. Most people who are first-time marriage people, they do not like prenuptial agreements. Prenuptial agreements are very important. Because what happens is, if you do not have a prenuptial agreement, the community of acquits and gains is going to kick in. And as soon as you get married, you know what's going to happen? That paycheck that has your name of it became your paycheck and his paycheck. Right? The other thing that happens is, he starts going to the mall, starts buying all kinds of pretty clothes, it's half your debt. Whatever assets are bought during the marriage, half and half. Whatever debts incurred, half and half. Okay? That meter starts running whether you like it or not. Here's the thing. This relationship is going to continue until one of only three things happens. Now, I don't care what you hear about on TV. There's only three things that are going to end the effects of your marriage. One is death. That will end it. Okay? Number two is a separate property regime. This is a postnuptial agreement. Just like you have prenuptial, you have postnuptial. Or you have separation. We're going to talk about this in a minute. This is an option to divorce. This is your only real option to divorce. And lastly, it is divorce. Please note, Very important for women to understand. Putting your name on an account does not make it yours. That's my bank account. My car's got that, my name's got on the title. If you bought that car during the marriage, I don't care whose name is on it, it's community. It affects third parties. It does not affect the relationship between the couple. Another thing, physical separation does not end the effects of the marriage. Very important. People oftentimes think, that blankety blank is out of sight, out of mind. I don't want to hear about him no more. He's out of my life. I don't have to worry about it. You better worry about it. Because if he's at the mall, he's running up a debt and it's half yours. And if you're making all the money, guess what? You're working for him. So it's very important. If you do nothing else, you must file a petition for divorce. Now, let's talk about the that separate property regime. Okay? Let's say we get married and all of a sudden we start having some difficulties here. And we want to change the rules. There's two ways we can do it. One is a postnuptial agreement. Just like you have a prenuptial, you have a postnuptial. Same type of document, you sign in front of a notary public and two witnesses. You say, look, from this day forward, what's mine is mine and what's yours is yours. In that case, that's a postnuptial agreement. The difference between a pre and a postnuptial, you got to go to court to get it approved. You got to go before the judge and say, I agree to change the rules. Prenuptial, you don't have to go to court. Postnuptial, you do. So it's a lot more expensive. Other thing is so the postnuptial agreement is something that has to be approved by the court. The other option is going to be where you and the other party can't agree to that postnuptial agreement. Let's say he says, I'm not signing that. If you've lived separate and apart for 30 days or he has abandoned you, you can file a petition to end the effects of the marriage and say, from this day forward, what's mine is mine and what's yours is yours. So you can do it involuntarily. This is not a divorce. The most common thing that people come to me when they do this, where do you do a postnuptial or they're having some problems, husband is off gambling on a boat and running up all kinds of debt and we want to stop. They still love each other, they still want to be together, but they want to stop the effects of the marriage. So this is an option to divorce. We did away with legal separation in Louisiana. Okay? We did away with legal separation. A lot of people think about it. We didn't do away with it in the covenant marriage. But in just regular divorce law, we've done away with that. So anyway, voluntary is an execution of a postnuptial agreement. It must have court approval. That's the postnuptial agreement. Involuntary, you have to file a petition. The important date is the filing date because that's the date the effects of the marriage ends. And you must be living separate and apart for 30 days or must be abandoned. That's the involuntary one. For divorce, I don't care what you hear about on TV, there are only 4 grounds for divorce. And 4 grounds only. The first is adultery. Okay? This is one of this remnant from the old days. Adultery is very, very bad. Okay? Culturally, and it's, don't get me wrong, it's still bad today, but it's really bad in the old days because if you have adultery, that whole family is going to break apart and everyone's going to starve. Okay? So it's really, fidelity is very, very big. Adultery is one ground. Second ground, incarceration. That means you have to be sentenced to death or hard labor. It means you're in Angola. You didn't just do a little misdemeanor, you did something really bad. You're in for hard labor. You did the very serious felonies. Okay? If your spouse has that, you can file a petition and get an immediate divorce. If there's adultery and you haven't reconciled, you can get an immediate judgment of divorce based on adultery. We're going to talk to you why I don't like to use adultery. As much fun as it is to use it, we don't use it very often. The most common ones that you're going to see is what's called Civil Code Article 103 divorce and Civil Code Article 102 divorce. Okay? Both of them involve living separate and apart for 6 months to a year. If you do not have minor children, you can be separated for 6 months without reconciliation. If you haven't been physically separated for 6 months, you get a divorce. If you have minor children, you have to wait 1 year. Now, 103 divorce is the one we really like to use because it's cheap, it's easy, and it's fast. This means you've already lived separate and apart for 6 months or a year. Someone comes to me and they've already lived separate, we file a 103 divorce because we can go right in, boom, boom, everyone signs their documents, it's done. You can be divorced very quickly, okay? So it's cheap, easy, and fast. The filing date is what is critical because that's the ending of the community. So, you wait a year or two and procrastinate, guess what? Your filing date, 1 year from today, whatever you got then is what you're going to use. And we'll talk about this in a minute on dividing community property. 102 divorce is for people who haven't lived separate and apart, but expect to. Let's say you come to me and say, I got all these minor children, we just got separated, protect me because I don't want him running off to the mall. In this case, it's still based on living separate and apart for 1 year with minor children. But what happens is we file a petition for divorce today, and they put them on notice, look, if we don't get back together in 1 year, I'm going to get a judgment of divorce. We file, we serve, or they waive service, we wait 1 year. If there's minor children, if there are no minor children, it's 6 months. Then what happens is, after that happens, you then can file the second plea to say, we now have lived separate and apart for 1 year or 6 months. And a hearing is held. And the judge normally just is done by affidavit. Unless there's someone saying we didn't live separate and apart for 6 months or a year, the judge will grant the judgment, and it goes all the way back to the initial filing date. So that's what protects you. This is what that legal separation, we did away with, but you can provide protection for yourself, but you have to file what's called a 102 divorce. A little bit more expensive, a little bit more time consuming, because what happens is you're dealing with an issue where, you know, it's a little more time consuming because you're dealing with two different filings here, and you're dealing with an actual court appearance by the attorney, at least the attorney. So those are your grounds for divorce. That looks like we took all the excitement out of divorce, didn't we? What happened in the good old days where we could go to court and just, he's a blankety blanket, she's a blankety blanket, you know, oh my God, there's all this hooping and hollering and screaming. Took all the fun out of divorce. That's it. That's it. Very simple process, but very important process. As women, you need to make sure that you protect yourself, because you know why? In community property, he or she that has the biggest ox is the biggest ox that gets gored. So if you're the hard worker, you're the one saving money, your ox is getting gored unless you file a petition for divorce. So if you do nothing else, you need to do that. Adultery. I don't like to use adultery. I know this sounds weird, because as attorneys you would think that we should. I don't recommend adultery in a lot of my cases. Unless I got two parties, husband and wife, saying it happened. Didn't reconcile, it happened. And they have two corroborating witnesses that say it happened. Okay? And here's why. Because if it is contested, number one, you got to prove it. These things are not easy to prove, okay? Because a lot of times they are circumstantial. They're circumstantial cases. So it's very hard to say, I'm going to win, unless you catch them in bed together, okay? Which doesn't happen very often. The second thing is going to be the time delays for a contested divorce on the grounds of adultery. It could take us 6 months, 8 months, a year before we get a trial date on this thing. Well, guess what? I could have gotten you an uncontested divorce a lot quicker and easier and faster. And lastly, and most importantly, and this really kills all the fun out of it, there is no legal, fault doesn't come into play in any of these issues except one, and we're going to talk about that in a minute. So the fact you drug him through the street and said he's a blankety blankety blank, guess what? You know what legal advantage you get in most of these situations? Zero. So if you get no legal advantage, why do it? That's why I say if it's contested, we don't recommend it unless the client signs a long letter saying, I told him not to do it, and, you know, and I give them all the reasons. That is divorce. That's from the date of filing forward. The way you have to look at it is divorce protects you from the date you file forward. Okay? So whatever you have after is your own separate property, your own separate debts. But the problem is we've accumulated stuff on the date of filing the divorce. That is what we call partitioning community property. That's dividing community property. That's what you had before. And again, the critical date of filing this is as soon as possible. Because you're going to see some really weird results if you wait a year, 2 years, 5 years. I had a client one time come to me, she was 15 years before she filed her petition for divorce. Only problem was he was in jail. And she was working. So he got half of everything she had. There's going to be an inequity here. You want to stop it. To protect you to the point of filing, that's the division of community property. Now I'm going to tell you something else that's going to take all the fun out of this. I know you heard on TV, I'm taking him to the cleaners and I'm going to take everything he's got and blankety blankety blank. Okay, well guess what? Under Louisiana law, that's not how it works. Under Louisiana law, it's half and half. Community property, half and half. The good guys, the bad guys, and everybody in between get half. Okay? So no matter how mean he was to you, he's still getting half. That's the law. Community property, and what I do to tell people is, community property is whatever property you acquired after you got married. You got married at 3 o'clock today. At 3:01, you buy a Mercedes-Benz. Guess what? It's community. The fact you put it in your name, unless you can show that you used your own separate money to pay for it and you got a paper trail, it's community. Debts, same thing. Most debts are community. Unless it's for a girlfriend, boyfriend, whoever. Golf clubs you didn't use, guess what? Golf clubs is still community. Okay? A lot of stuff is considered community. Separate property is going to be that property which you brought into the marriage. Brought into the marriage. You know, if you brought furniture or clothing or you brought, this is separate property. Now, and whatever debts you had prior. Separate property can also be inherited property during the marriage. But here's the problem. The problem is we have exceptions to the exceptions. And the exceptions to the exceptions are that with separate property can in time become community property. If you start mixing up separate money with community money, it becomes community over time. And we don't oftentimes keep things as separate as we should. The other problem that you got is income from separate property is community. So if you got a bank account that's drawing interest over time, over 10 or 15 years, and it's mixing up with this income that's coming in, it's mixing up with your separate asset, over time, it may lose its separateness. And that's the problem. That's why we do prenuptial agreements. Because we say, my name's on it, it's mine. Your name on it is yours. We keep it clean. The problem is, when people get married, these lines become blurry. Even though you thought you had separate, it becomes community. It's almost like a cancer. It's eating away, and you just don't realize it until you start looking at things. That's why prenuptial agreements are so important. Dividing community property. There's two ways to do it. One is by an agreement. Let's say you and I say, okay, we got all this stuff, but I'm going to take this and you're going to take that. If we have an agreement, we can voluntarily agree by agreement in front of a notary public and two witnesses that this is yours, this is mine. Now, here's the thing. When it comes to community property agreements, there are some rules of thumb that I tell everyone that you must follow. Number one, you want it in writing. Why? Because verbal agreements are not enforceable. And he'll come back in 2 years and say, I didn't say that. I didn't say you could have that car. Right? Want it in writing. Number two, we want it comprehensive. We're going to agree to everything, or we're not agreeing to nothing. Why? Because if you give away all this cash over here, and it leaves you with this little bitty thing over here, you may need that cash to equal things out over here. And you've just given away part of what you need. So from a practical standpoint, it's not good to do stuff piecemeal. Don't do that. People get burned with that all the time. I'm going to give him the car. Oh yeah, give him the car. Guess what? You just gave away a significant asset. Lastly, you need to make sure that debts are paid. If you have money to pay debts, please pay them off. You know why? Because if he assumes the debt and doesn't pay it, the creditor's coming after you. Even though you have this nice pretty agreement with all our notarial stuff and it looks all nice, guess what? Creditor doesn't care because they didn't sign the agreement. They loan money to you as a couple. They don't care that you two said we're separate. So this document doesn't protect you unless you pay off the debts or you have him refinance in his own name after you file the petition. So you refinance these debts. If he wants the car, he's going to get the car. He's going to refinance in his own name after we file the petition for divorce. That makes it his separate. If he can't do it, sorry, we're selling the car to somebody else. Because otherwise, he or she can burn you if they don't make the payments. Another thing that's very important that people need to do is going to be bank accounts. When you file your petition for divorce, and these people hate to do this, and I understand why, but they got to do it. When you file a petition for divorce, that old bank account you had, you treat that one like cancer. That's community. When you file your petition for divorce, you open a new account in your own name with new money. You check for next month, goes in there. Everything goes in there. Why? Because this is community. If you mix them up, it's community, right? You don't get a credit if you start paying debts. Whereas if you use this new money over here to pay a community debt, you get half a credit. In other words, if you paid $2,000 worth of credit card debt, you get $1,000 back. It's part of the litigation. That simple thing of doing that can be significant amounts of money. You got to take that extra time to go to the bank and open up the account and then put the new money and don't let the two things get mixed up. If you can prove the paper trail, you got the reimbursement claim. That's the way of doing things. Partitioning community property involuntary. Let's say you and the blankety blank don't want to agree to nothing. Don't want to agree to nothing. Then what happens is, what you have the right to do is file a lawsuit and say, I don't want to co-own this property with him anymore. I want you to figure it out, court, because we can't figure it out. You file a lawsuit, he has then 45 days to agree or disagree with your detailed list, where you're going to list every stick of furniture, list the value. If he agrees with everything or doesn't take any action, the court will use your list. If he disagrees, he's going to line item it. He's going to say, I agree with A, I disagree with B. That way we're figuring out what are our issues here. There's only two issues before the court that's going to be litigated. Is it community or separate? And what's the value? That's it. So we're going to start narrowing these issues down. What ultimately could happen is you could have a trial where the court has to litigate these particular items that you're contesting. And they ultimately decide who gets what. They're going to divide it half and half. So that is a separate lawsuit that's filed, but it is filed in your petition, in your docket for the divorce. Okay, so that's why I call it incidental, because you piggyback it onto the previous filed divorce. You cannot file child support or all these other issues unless there is a previously filed petition for divorce. Partition agreements, I want to follow up with one thing. Partition agreements, and this is something that a lot of people are unaware of. You can actually, if you have an agreement to divide, you don't have to have marital problems to do it. You can be married and divide your community at any time. So you don't, just because you're happily married, you can still divide up what you got by agreement before no Republican Jews. That's the exception. Everything else piggybacks on the divorce. Let's talk about child custody. This is the most litigated part of, this is where we have the most fun, okay? There's more emotionalism and more money made on this issue than any other issue, okay? And let's talk about this, why it's important for women, what women need to know. What women need to know is that if there is no judgment in effect, it is jungle rules. He or she that has the child makes the rules. If you pick them up on a Saturday, that you make the decisions for the child. But if your husband picks up the child and doesn't bring the child back, he makes the rules. Okay? Now, don't get me wrong. I'm not encouraging people for hiding kids or keeping them away, because that factor can ultimately be used against you. But here's what the proper answer is. The proper answer is you either need to agree to a judgment, or you better go to court to have it litigated. Because if you don't, you have nothing. Okay? Now, let's talk about some legal terminology here. There's this real pretty word, joint legal custody. Oh, when I got out of law school, this was the thing. Oh, these people came up with this great idea. We're going to have joint legal custody. And when people get divorced, they're going to operate together, and they're going to jointly work together to resolving issues on the children, and it's going to be a wonderful thing. Stupidest law we ever wrote. Dumbest law we ever wrote. You know why? Because you had people locking horns, 50-50. Couldn't make decisions on school, couldn't make decisions on who the doctor was. What happened? It all went to courts. Judge had to listen to all this. Judge said, we tired of listening to this. We're going to change it. So they left the real pretty word. You have joint legal custody, and it's presumed, but we gutted it. And basically what it has is that whoever is the domiciliary parent, whoever's named, who is the primary caregiver, gets to make the decisions. And if the visiting parent doesn't like it, they have to take it to court. Then the visiting parent gets a visitation plan, or it can be liberal visitation. The parties can agree however they want. That's the general structure for people who aren't getting along very well, which is 90% of them. Okay? So what you normally will see is, now there is a provision that courts are not going to discriminate for sexual reasons, men or women. There's also a provision that they're going to try to equalize the time as best they can. But as a general rule, and again I'm painting with a really broad stroke here, so forgive me. As a general rule, you're going to see the traditional, if you go to court and two parties are fighting, you're going to see joint legal custody, which now only means the domiciliary parent must consult with the visiting parent. Does not have to agree with them, just has to talk to them, can make their own decisions. The domiciliary parent makes the major decisions. Visiting parent for children that are of school age normally gets the children every other weekend, alternating major holidays, extensive visitations in the summer, what you normally hear about on TV. Okay? With regard to children, so that's what we normally have when we have school-age children. It's the customary thing you normally see on TV. However, children that are preschool age is a little bit different, because this a lot of time is going to be a little bit more fluid, because you don't normally have school. So what happens is, what you're going to have is normally it's going to alternate based on the schedules of the parties, their work schedules. Okay? And a lot of judges will normally try to make this as much as possible, especially very young children, because what happens is you'll find, I know this sounds really bad, but like really young children kind of forget who their parent is, okay, because they don't have memory. So they're constantly being traumatized every time you go back and forth. So they try to do more frequent days. You know, you may have the child being transferred every couple of days. That way, otherwise, if it's every week, the kids go berserk on it. So anyway, there's a more of an equalization, there's more fluidity, but the judge is still going to probably try to have a domiciliary parent and a visiting parent. We have what's called shared custody agreements. Now, this is where we're going kind of back to joint legal custody, and this has become more common. This is where a lot of times this is where both parties agree. They agree to 50-50. I'm taking the child this week, you take the child next week. We're going to share, and I'm going to take care of the child when I'm here, and you're going to take care of the child over there, and we're going to equal out the time. That's a shared custody arrangement. In this case, it becomes problematic because we don't have a domiciliary parent. In this situation, you really have to have two parties getting along. You have to have almost an agreement. Most judges, every judge is kind of different on shared custody. They have their own philosophy. But as a general rule, you'll generally find that shared custody is only normally brought into play if both parties agree. Because you really got to work together for shared. You know, you got to really kind of get along, okay? So if a woman comes up to me and asks me, Kent, what kind of wording can you put in judgment that gives me everything? I would recommend joint legal custody. Give them an apple. They think they got all kinds of stuff. They don't have, all they have is consultation. We're going to make you the domiciliary parent, major decisions, and we're going to say liberal visitation. Liberal visitation means either party can veto. That means you have all the power. A lot of pretty legal words, it means you've got all the power. Do I agree with that? No. I think that really the better thing for people is to have a set custody plan. I think it's very important for kids and the parents to know when daddy's coming or mama's coming to pick up the child. Because liberal doesn't always work out too well, okay? And toes get stepped on and you got different issues. I find it's better if everyone knows what's going to happen. However, as an attorney, I would tell you, write it up with all the pretty language. Let's talk about child support, okay? Child support is something that the way we calculate it is, we calculate it based on the gross incomes of the parties. We find out how much gross income do you have, how much does this party have, okay? Gross income. We take those two incomes and we have this guideline. Got all the numbers in it. We find out how many children you've got, and we crank out a number. And I'll show you in an example of how we do it. There used to be more fluidity before they came in with the guidelines, and we had all these different results going on. So they wanted to make things more standard throughout the state. In addition to the base amount, you also get extraordinary educational expenses, child custody expenses, medical insurance, and things not covered by insurance. Okay, so we use the guidelines. We calculate the amounts based on the guidelines, and I'm going to show you how we do it. Okay? Basically, what happens is, in this case, there is a rebuttable presumption that this amount is the amount we're going to use unless the court decides they're going to deviate down because it's not in the best interest of the child or because it's inequitable between the parties. And so this is how we do it. We have a husband's income. I'm making $2,000. You have income, $2,000 gross. We combine those both together and we got 2 children. That means we got $4,000 of gross monthly income. We take that $4,000 and we go into the guidelines. $4,000, 2 children, and we crank out a number. The base amount that is owed is $1,026 for the care of 2 children with this income bracket. Now, what we do is, I make 50% of the income because I got $2,000 or $4,000, and you make $2,000. That means that what we're going to do is we're going to take 50%. We're going to cut it in half. If I am not the domiciliary parent, I owe the child support. I'm the visiting parent. That means that I owe 50% of $1,026, which means I owe $512 for 2 children. That's what the guidelines say. Sounds kind of high, huh? I mean, that's what it is. $512. in addition to that, you can also get me to pay 50% of the child care cost.